Welcome back to U.S. History with Mr. DeCecco. If you're here, it's because you made it through World War II and in the beginning of the Cold War. And now we're going to look at the struggle for civil rights in the 1940s, 50s, into the 1960s. To help you get a gauge of that, though, we kind of have to go back to see the position of African Americans in the post-Civil War era. So what we know is that most African Americans face discrimination both in the North and the South. The Jim Crow laws that were created really limited the freedoms of African Americans. And if you ever see Jim Crow laws, you want to associate that with segregation. That's your separate drinking fountains, separate schools, separate playgrounds, back of the bus sort of thing. This is what was created in southern states to really hinder the availability and development of what African Americans were able to do. You'll find that discrimination both in North and South, but truly down South, those white Southerners continue to maintain total control over what African Americans were doing. So this is not something that you wouldn't see maybe 1940s, 1950s. He's saying, treat me as an equal, and this guy, obviously doesn't want to be around him, and he kind of has that sheepish grin about him. It's kind of not a good time for African Americans, right? Kind of what's interesting here is you can see the onlookers not really doing much about it, right? So when we look at the beginnings of change, we have to understand where we were first, right? By the mid-1900s, so we're looking at 1930s, 40s, 50s, the South and North was segregated. I mean, separate all the way through. African Americans were restricted to living in poorer neighborhoods, not by law, but simply because they weren't given the high-paying jobs which allowed them to move to the more affluent areas, right? African Americans' gains were limited, even though they fought for change. We see very limited change for this group of people in the 30s and 40s. By the time we get to 50s and 60s, you're going to see a lot of change, right? The first major event is in 1947. The Major League Baseball was predominantly all white players. There was a separate league for Negro players. They were actually called the Negro Leagues. And in 1947, Jackie Robinson, who happened to be African American, he was so good that the Brooklyn Dodgers said, I don't care what color he is. The owner of that team said, I want him playing on my team. Public attitudes did begin to change. Jackie Robinson will face discrimination in the major leagues. They spiked him. They called him a multitude of names, but he managed to continue to be obviously one of the very best baseball players for 2-3 years in the major leagues. So it really showed that black and white can come together in multiple facets of American society. So the other big change that happens right after, 1 year after Jackie Robinson plays baseball, is Harry Truman changes his stance on civil rights. He was the president, and he tried to do it via leadership and ended up having to come up with a very decisive action. So what did he do? He appoints a commission to kind of review what's happening between African Americans and white people around the country. So he wants to get the information first. He begins this in 1946. He calls for an establishment of fair employment practices, which was kind of asking businesses to do the right thing, but really didn't force them to do it. And that's where the rub meets the road here, because this commission comes up with, hey, here's what we should be doing in American society. Congress doesn't really do anything about it. So there was no laws forcing people to do this. Well, in 1948, Truman issues his executive order 9981, which says that black and white in our armed forces, whether it be the Army, the Navy, the Air Force, they will fight together. Desegregated units, integrated units they were called. And if you watch any movie or documentary about, World War I, Spanish-American War, World War II, you will find that this goes all the way back to the Civil War. There were all black units and all white units. And if you follow along into my next video, that's going to be on civil rights, and the one after that will be on the Korean War, you'll see that black and white begin to fight in the same units, right? So Truman is the first president to really do something about the black and white issue in American society. So here you see, this is a picture from Korea. You say black, white guy in the same foxhole fighting shoulder to shoulder. You would not see something like this from the Civil War or both of our world wars, right? Well, what's going on with the court? So we're going to introduce you to the Warren Court here. Justice Earl Warren became this Supreme Court justice, appointed in 1953, and it becomes, there are so many decisions made here. This becomes known as the Warren Court. And if you want to remember anything about the Warren Court, just remember that the Warren Court was really favorable to those minorities, to African Americans, to the people who were possible criminals, to religious groups, very fair to all those other groups, right? So this court rules in favor of African Americans. For maybe the first time in American history, our Supreme Court began to do things for a particular group of people that probably needed to be done 100 years earlier, right? So there's Justice Earl Warren, and it will be known, forever known in American history as the Warren Court. So I'm going to take you through a bunch of court decisions about a bunch of different groups. So let's start with the civil rights group. So this would be your African Americans. Two major court cases impacting what African Americans were allowed to do. First off, Brown versus Board of Education, 1954, Linda Brown. It really ended the segregated public schools. Notice this had nothing to do with private schools, particularly public schools, and basically said black and white children are allowed to go to school together in public education. I'm gonna go a little deeper into that case later on. Stay tuned. Heart of Atlanta versus United States. Heart of Atlanta was a motel in 1964. Before that, the case comes out in 64. An African American man showed up. He was traveling, and he wanted a room, and they denied him because he was black. Well, the Supreme Court basically came out and said that discrimination in public accommodations is illegal, prohibited. You are not allowed to do that. You're breaking the federal law. You are violating the 14th Amendment Equal Protection Clause if you do not give that man a room. So it really put some pressure on private businesses to enable certain groups of people access which previously they did not have. Okay. What if you're a criminal? Well, criminals certainly still have some rights. So these four cases deal with the rights of the accused. Doesn't mean they're guilty, means they were accused of something. And in our country, we believe that you are innocent until proven guilty. So I'll run through these four pretty quick. They're pretty easy. Matt versus Ohio is the exclusionary rule, as we call it. So if the cops roll into your home, if the cops search your automobile, they put your hands in your pockets, and they seize something illegally, if there was an unreasonable search of your stuff and seizure of your stuff, that information will not be used in court. Once again, the cops have to follow a certain amount of rules, and if there's not a warrant or probable cause, or they have no business putting their hand in your pocket, grabbing your stuff, well, even though they've taken it from you, that information cannot be used in court. So it protects you against illegal searches and seizures. Gideon and Escobedo kind of go together. Gideon was a very poor man who was arrested of robbing a pool hall, ended up going to court, and he was obviously found guilty. Well, in the appellate courts, in his appeals, the authorities did not give him an attorney during the court proceedings. So in Gideon versus Wainwright, it establishes that no matter what, all defendants have a right to an attorney during the trial. You cannot be denied that. You can deny it yourself. It has to be afforded to you. They have to still give that to you. Escobedo versus Illinois. Gentleman Escobedo was arrested, and he was put in a little room, and the coppers were asking him tons and tons of questions. And what they decided in this appellate was that even during questioning, when you are taken into custody, you don't have to answer a thing. You can request to have an attorney while you are being questioned. So Gideon, you get an attorney during the trial. Escobedo, you get an attorney when being questioned. And then finally, your Miranda rights, 1966. At the time of arrest, you have to be informed of your rights as a citizen. And those rights are, you have the right to remain silent. Anything you say can and will be used against you in a court of law. You have the right to an attorney. If you can't afford an attorney, we're going to get you one. Do you understand these rights? As soon as they read you those words, you are under arrest. But realize that even while you are arrested, you do have certain rights. So once again, you put these four together when you study them. These are all the rights of the accused, people who may be possibly criminals. Okay, this is weird when they came out in a real kind of religious area up in Connecticut. What the state of Connecticut tried to do was to make criminal the use of contraceptive devices, whether the woman takes a pill, whether the man uses a condom. If a family decided they did not want to have a child, the state of Connecticut made that a criminal act. And what the Supreme Court decided was you should have control over your body, over your family. So what the Supreme Court decided was what Connecticut attempted to do was illegal. They are not allowed to make contraceptive devices illegal. These two are involving our federal government and how states had a say in the representation in Congress. They're pretty easy. Baker versus Carr says that whenever legislative districts are reapportioned, they have to be reapportioned equally. And that's pretty much all that's happening there. And then Reynolds versus Sims, the legislative districts have to be equal in population. It's a misrepresentation of a state if one legislative district has 60,000 people and another legislative district has 10,000 people. So every 10 years when there's a census done, if they change the voting districts, the population has to be equal in every district. So those are pretty easy ones. The last few here are about the First Amendment, and notice they're all happening in the 60s. The 40s, 50s, and 60s was a great time period for people's rights at the expense of what the government is able to do. So these three involve the First Amendment rights. You should remember your 5 freedoms of the First Amendment. Freedom of speech, freedom of press, freedom to assemble, freedom to petition, and freedom to express yourself, right? Well, Engel v. Vital in public schools, they were holding a prayer time. Now, what the court said was, in a public system of education, you cannot force students to pray. You cannot force a particular religion upon students. That doesn't equate to the private schools. If you're paying tuition, the school may put you in a particular religious class and may ask you to pray certain times a day. What Engel v. Vital does not do was it does not prohibit you from praying. If you want to go off in the corner and pray, you're more than welcome to. Okay. New York Times v. Sullivan. People say things about public officials, and there's these terms we throw around. If you say it, it's slander. If you write it in a newspaper, you're liable for what you print. So kids always ask me about, like, what about the National Enquirer? They say all wild and crazy things, and no one ever sues them. Well, it's because of this case, 1964. Statements about public officials can't be considered libelous unless they're really made with actual malice. So if it's kind of a joke magazine like the Enquirer, and people read it for hilarious value and they just enjoy it, they realize that what they're reading is not going to cause malice. It's just a formality for a quick laugh. If you are saying something malicious, though, then you will be charged for slander, or if you write it in a newspaper or print it on the internet, it could be libel, right? Tinker v. Des Moines is the kids love the most. 1969, a bunch of students decided that they wanted to wear a black armband to protest the Vietnam War, and they did this. They were suspended, and the Supreme Court said that this symbolic speech is protected by the First Amendment. So the school district would need to show that those students were causing a disruption to learning. And by wearing a black armband, what the Supreme Court said is that it wasn't really disrupting learning. It's basically violating those students' freedom of speech to be disciplined. So the court backed up the students' rights in this case in 1969. So I'm going to get back to the actual civil rights now. Pay attention to those cases. So if you have my worksheet and you're filling those out, those are the good ones to study, 1940s, 50s, and 60s. So getting back to the civil rights movement, we know about Jackie Robinson. We know about integration of the military by Harry Truman's executive order. So let's really dive into this case, Brown versus Board of Education, right? Happens in 1954. The young lady in question here is Linda Brown, young African-American student. She wanted to go to a local school. It was right down the street, all-white school, rather than attend the all-black school that was really far away. She was obviously denied, right? In 1896, Plessy versus Ferguson required that you can separate black and white people as long as you gave them equal facilities. So, based on Plessy versus Ferguson, Linda Brown had to get bused to the all-black school. And in 1954, the Supreme Court changed their mind. And in the Brown decision, they said that education is not the field of separate but equal. It isn't right to separate black and white people in public education. Keep that in mind. This court case is only dealing with public education. Did not deal with private schools, did not deal with private colleges, only public education. The other problem with this court case is, although the Supreme Court said that this is not allowed, it told the states that they needed to desegregate the schools, but didn't give them a time period as to when to do it. So you and I both know that those schools down south who had segregated schools weren't in a huge rush to bring black people into the white schools, which gives us this is a nice picture showing that, these people are in favor of moving forward with the civil rights movement, right? School segregation banned. There's your Justice Earl Warren. There's Linda Brown, if you want to see her. What happens? Well, 3 years later, in Little Rock, Arkansas, integration wasn't happening. Southern whites, those southern schools, they campaigned what was known as a massive resistance. We are not going to let those kids into our all-white schools. That's what they said. The Supreme Court said that, hey, you need to integrate the schools with all deliberate speed, meaning do it very quickly, but didn't really give them a timeline. It just said that it needed to be done. Well, many schools are going to defy this ruling and drag their heels. So, in 1957, 9 African-American students wanted to go to Central High School in Little Rock, Arkansas. The Arkansas governor ordered the National Guard to not let them in that school, and he did. He denied them entrance. So here you go, the African-American kid walking to school, National Guard, look at their face. They're not going to let that girl in. Look at this white mob back here. They are not, look at the faces. They are not going to let that girl into that school. They threw rocks. They spit on them. They beat them kids up. It was bad. They were denied by the students, by the white families, by the Arkansas National Guard, and by the Arkansas governor. Now, what happens? Well, our president said that, hey, the Supreme Court said that schools are integrated. They must be integrated. So he sent in the federal troops to escort those kids to school. And they did. Governor Orville Faubus tried to close all the schools. He's going to fail at doing that. Education is a responsibility of the states. 1959, the first racially integrated class graduated from Central High School. So when you see these images here, right, that kid's being escorted by the Army now for a year, the whole school year. He went to school with his Army. And obviously nothing happened to those black kids because they had some protection because of Dwight D. Eisenhower. Well, nice little outline for you. Containing the major events of the civil rights movement. So when you look at the years here, you see where it's really taken off, right? I'm going to go through one more event known as the bus boycott later for you, but if I were you, I would check out this outline as to the major events that took place during the civil rights movement. All right? Now, public facilities of all kinds were segregated. You know the laundry list that were there. Rather than wait for the government to fix it, this is why we call it the civil rights movement, because the African American communities began to gather together to do something about this idea of segregation. And the biggest example happens in 1955, right? This is known as the Montgomery Bus Boycott. In 1955, an old seamstress, or you know the name, Rosa Parks, she refused to move to the segregated part of the bus. She was arrested, which was customary at that time if you did not move to the appropriate section. And the movement begins. She was arrested. Her action inspired what's known as the boycott of the city's buses in Montgomery. Dr. Martin Luther King the local chapter of the NAACP in Montgomery, Alabama, organized the black community. They said, not one of us going to ride them buses. Not one. And they boycotted for 381 days. And for that 381 days, I will tell you that bus company's not making any money. And eventually, the bus company's going to want those people to come and ride those buses so they can make money. And even the Supreme Court ruled that segregation of public buses was illegal. Now, I need you to take this one step further. If public buses are illegal, what about public transportation? If you can't do it on a bus, you can't do it on a train. If you can't do it on a bus, you can't do it on a plane. So what came out of this boycott, this activism, is public transportation had been desegregated. So I want you to pay attention to those major events that are happening underneath this early part of the civil rights movement. And I actually have a second half of the video that covers Dr. King's speech and the Civil Rights Act that follows 1964, 65, and 66. So this is just the first half of what has been going on, and we'll deal with that second half later on. Best of luck. Keep studying, and see you soon.